We're going to talk about two things today, so that's business succession and estate succession. So look, we'll start off with the business stuff. So can anyone tell me what are people buying when they buy a business?
Asset.
An asset? Okay. So what are the types of assets? What do they buy? Property, totally. Anything else? Plant and equipment. Okay. What's the other one? There's really goodwill. So and really goodwill is a couple of things. So it's you're buying the future earnings of something basically, because if you talk about a balance sheet, goodwill's the difference between what all the stuff you own is worth and then what someone's willing to pay for it. So the goodwill is basically made up of both your ability to pay to make money in the future, and then a little bit as well, depending on the type of business, for the blue sky, the future, the other things that you can do with these assets. So with doctors, we quite often find that business succession can be really hard because so much of that goodwill can be just tied up in the personal doctor. So for when the accountants go out and do a valuation of the business, they'll usually talk about future maintainable earnings. Now, that maintainable part, that doesn't happen unless you have some ability to capture that goodwill that's currently potentially really tightly held with the doctor. So the job for you guys is going to be making it so that value that sits within you can be broadened out and shared and then obtained by someone in the future, because that's when someone will be willing to pay for it. So, and there's a few steps you can take to make sure that happens. So we're going to go through some of those things, and then we're going to talk about estate planning. So what you can do personally to ensure that you get assets from yourself to your family in a tax effective method, and hopefully as far as you can stave off any real dramas. So have your assets going somewhere other than where you intended. So we'll start off with the business stuff, and I'll let Benny talk about some of the steps we can start taking.
All right, so I'm going to sound like a broken record for the third day in a row, but really when you're talking about succession planning and planning for, you'd like to think not your demise, potentially your business partner's demise, but we like to incorporate into any agreement as lawyers the worst case scenario. No one likes to think about it, but it has to be thought about and it has to be documented. So no matter what structure you pick, your agreement should contain at the very least some provision for what happens in the unfortunate event that you or one of your partners meets their unfortunate demise or is totally and permanently disabled, or essentially is just no longer able to work in the business with you. So they're TPD events, and essentially they trigger a sale event where that partner either first sells to you and you have the opportunity to buy it from them, or you can then sell it to a third party. So the main intention behind this is if you have a company and the shareholding is by your partner's family trust or family, it may go to his partner, who may not be a medical practitioner, and then you're going to be trying to run a company, if you don't have one of these clauses, with your partner's partner. And you may not get along very well with each other, so you want to ensure that you have those clauses in the agreements that provide for an automatic sale so that you can deal with the problem as it arises and make sure that your business can continue on without them. It's not a very happy topic, but one we have to talk about nonetheless. So really, this comes back to the point we've been talking about the whole weekend of what is your structure, and ensuring that the structure you pick at the outset is the structure that's going to work for you, hopefully for the life of your practice. Now, if you're planning at the outset of exponential growth, multi-practice, multi-site location, talk to your advisors, talk to your accountant, and make sure that they're setting you up on the right framework and taking the right steps to help you achieve your goals. Because, and we'll talk about it in a few slides, but the potential tax implications of transferring assets and transferring your business structure from one to another to make it better for scalability can be significant. In terms of trying to future-proof You're all quite young, and you've got the advantage of being young and being able to run all of your personal and other financial interests potentially through trusts and companies. At the moment, we have a client, and they've built a very successful multi-site practice location, making several $1 million of profit a year. Unfortunately, they're coming to us talking about succession planning. They're hoping to retire within a few years and thought it was going to be very easy. They were just going to put it out to tender to their associates and some of the other equity directors. Unfortunately for them, they've been paying for all of their personal hobbies and everything else through the company. So this very successful multi-million-dollar practice has a book value of about $100,000. So they were running a personal farm through there and all sorts of things. So we sat down with them, we sat down with their accountants, and we said, look, guys, appreciate that this has been a massive financial benefit for you, but you've shot yourselves in the foot by leaving it a little bit too late to try and actually give yourself a true book record value for your company. Because the lawyers on the other side will come in and they'll say, hang on a minute, whilst this company's making an absolute fortune over here, it only has a book value of $100,000. Something's not right, and you start sniffing around and you figure out what's going on. So now we're trying to true up their value and help them get everything back into order. But it's a case of don't get too carried away in the early years. Make sure you keep talking to your financial advisors and your fin planners and your accountants to ensure that you are setting things up the right way, running them the right way, and not leaving things too late if you are wanting to potentially sell your business in the future, so that you don't shoot yourselves in the foot, because that's a very expensive, very painful lesson for our clients to learn. Fortunately, they can afford it, but I'm sure they'd prefer that money to be in their own pockets like all of us. So definitely when you're talking about succession planning and planning for the future, we've spoken for the last 2 days about setting yourselves up properly and facilitating that growth. It's a whole lifelong phase that you need to be planning for, not just getting yourself off the ground. You want to be thinking about how do we best position ourselves in the future so that when we do want to sell our business, if we do want to sell our business in the future, it's very easy and it's very effective. If you do everything properly at the start and you talk to your advisors and you let them know what your plans are, you can usually minimise a lot of the cost, a lot of the tax, a lot of the other painful pinch points in the future. So as we've said the whole weekend, take the time, communicate with everyone around you. If you tell all of your advisors what you're planning on doing, we can help plan for that whilst you guys are doing what you do best, which is practicing medicine.
We've already touched on this a few times. It's really important that you have your service agreements in writing, written down, so that a potential buyer can get a handle for how the money comes into the practice, how it goes out of the practice, so that they know what it is that they're buying. It's really as straightforward as that. It's just got to be written down. It's got to be clear. In terms of the goodwill that I was talking about before, if you have this wonderful practice, and maybe it's just two of you, but you'll probably be both at the same age and stage. You don't get to your 64th birthday and go, all right, it's time to retire. We'll be retiring next year. Let's sell our business. You really need to, it's called succession planning for a reason. You've got to plan for it. So you need to be looking out 20 years, 15 years, 10 years, 5 years. What's my actual exit plan here? You really shouldn't get involved in an investment without knowing what your exit plan is. So is your buyer going to be a corporate? Because you're going to want to set things up a different way. And look, there's not as much corporate activity with specialists now, but I think you'd be crazy to think that it's not going to happen, because we've seen it with GPs. And there's a few happening now with, like, I know Heart Care Partners, for an instance, they're starting to get practices everywhere in big numbers and things like that. So I think you've got to expect more of it. So, 20 years ago, the idea that you're going to be bought out by a corporate wasn't on the table, and you were just going to probably get an associate, train them through, and then their list would effectively become your lists as best as you can manage it, and they might pay you something for it. Whereas now there's more than one option on the table. Or is it the traditional method where you are going to have other specialists coming through who will effectively, you'll introduce them to all your referrers, you'll give them your overflow work, and eventually they will buy out your practice. So that's just something you've got to think about on that front.
Look, ultimately, when you talk about succession planning, if you're the type of person that doesn't want other people to do the work for you and you want to hold on to everything and build your practice and you're the keystone centre pillar for that practice, it's very hard to then turn to someone and say, buy this practice off me, because you essentially are the practice. So when you leave, all of those service fees that are coming in and everything else that are coming in drops off with you. So succession planning in part as well is making sure that you have that network underneath you of associate doctors and other potentially equity doctors who are there and able to generate those fees for you, and potentially external fees that you can generate for the practice as well. So thinking about future-proofing your business so that it can survive without you also facilitates you having those holidays throughout the way when you've got people that can keep your business running for you without you having to actually be there. In terms of documenting everything and making that succession planning and the sale event as easy as humanly possible, when you're thinking about selling a practice or buying a practice, you want to look at the structure of the practice, but you also want to look at what it owns in terms of assets. If it's got the whole building that it owns and it's subleasing or leasing out premises to other people that's generating income, that's an appealing option for some people. Additionally, you want to be looking at, well, this practice has 40 staff, but does it have 40 employment agreements or service agreements or whatever the mix may be? If you've got 40 staff but 5 people with proper employment agreements, the incoming purchaser is going to say you've got 5 staff, and the 15 are outliers that may be generating fantastic revenue for you, but they have no guarantee that those people are going to be staying there once they buy the practice. You want to be able to give them some certainty and some clarity.
If you've ever tried to get someone to sign an employment agreement after they've been there for 8 years or 10 years or 15 years, it's a really hard sell. So if you don't do it at the start, you're really going to be pushing you-know-what uphill to try and get them to sign it later. So earlier is better.
Really, you should be, before you bring on any employee, any doctor under a service agreement, you should be trying to avoid going, oh, come on, we'll do the work and then we'll eventually sort out this agreement or we'll negotiate it. Really want to have that document set in stone before they even start work and say, look, here's a future date when you're going to start working in. It can be a day if you want it to be, but ideally you want to have that agreement in place and signed off before they start doing any work for you. Retrospective agreements are inherently risky, so you want to avoid those as much as possible. Additionally, when you are looking at your business structure, a lot of these principles apply throughout the life of your business. So you want to make sure that when you are preparing for a succession event, you're looking at employee leave entitlements. As a matter of law, if an employee leaves, they have to be paid out their annual leave entitlements. And so that can be a very significant payout figure that someone might be taking on when you leave. Also look at your sexual harassment and bullying policies, IT and security, workplace health and safety, and performance management. So how you handle issues within the workplace. Pretty much every workplace now has Wi-Fi and computers and internet provided as part of an employee's computer. If you don't have an IT privacy policy or a proper use policy for those websites and internet access, can create some issues for you in the future. You want to have very clear usage requirements for what the purpose of internet access is for your employees. Additionally, that makes the succession planning a lot easier when you can say to your incoming purchaser, here's our employee handbook that we give to every single employee that governs how they're going to work for us. They can pick it up and they can say, this is really good. This is your McDonald's event where it's very clear we can take this and we can replicate it across, and the blue sky, keep building your business off once we've bought it. So if you make your business as attractive as possible, you're actually doing yourself a service as well, because you're doing everything that you possibly can to protect yourselves. So it's not just about getting a nice payout at the end of the day, it's about minimising risk throughout the life of your practice.
Okay, so these are really the steps you actually will have to take. And this also ties in with property. So I caught the end of the last presentation where they were talking about, you know, you might want to get some more money into super. So you've gone out and bought a building and then you're charging that rent, which is an effective way to potentially get some extra money into the super fund. So when you're talking about selling your practice, what are you going to do if your buyer hasn't got the money to buy the building at the same time? You might have to take into account the fact that, especially if you're selling to your associates, you might end up holding that building for longer than you planned, because you might have to give them a 10-year lease, a 5-year lease with an option to buy, and it might need to be a put and call option. So what that is a call option is, so I give Ben a call option to buy the premises, but at the same time Ben gives me a put option where I say, here, you're going to buy this off me for this price. So you have to think about how you're going to deal with that.
You very well may decide that you're going to sell the practice and keep the building, and then you know that you've got yourself an anchor tenant and you've got all the tenancies there still. So you don't necessarily have to sell practice with building. It may make the offer more appealing to your incoming purchasers, but there's a million ways that you can cut a deal and provide for the best thing possible for yourselves as well.
And look, what I'd suggest is very regularly you should really get your business sale ready, even if you don't plan on selling it. So every 5 years, go out and get it valued, go out and have an accountant go through your books and give you a rough idea of what you think the business is worth, because it'll help you in negotiating with banks, it'll help you negotiating with landlords, it'll help you negotiating on all sorts of things. And then if that corporate does pop up and has an offer, you have a really good idea if it's a good one or not. If you have no idea what your business is worth, you might go and sell it, and then 2 years later you go, geez, I could have got heaps more for that. So just by going through that process continually, you'll also just reap all sorts of business improvement benefits from getting that business sale ready over and over and over again. It's really worthwhile. It'll just keep you on the right track, keep you focused, and set you up for a good result.
Fun stuff now. So your personal succession planning. So no one likes to think about their own mortality, particularly when someone young's telling you about your own mortality. It makes it even worse. That's why usually estate lawyers are grey-haired and very senior solicitors. So I'll try and make this as painless as humanly possible.
Yeah,
but
you don't want Ben to be the one signing your will. You always want it to be someone who you think's closer to the grave than you. You know, not this guy.
Yeah. Essentially, so estate planning is planning and providing a document that will govern how your estate is administered. So if you die without a will, it's called dying intestate, and essentially it means that the public trustee is appointed to administer your estate. The public trustee takes a clip of your estate as payment for administering it. So typically with a will and enduring power of attorney, you can choose who your executor will be, you can have multiple executors, you can direct who your beneficiaries will be. If you have multiple children, you can say, I want 50% to go to my firstborn because they're my favourite, 25 to the second, 25 to the third. Or you can split it however you want. The one thing I will say is however you want to slice it and dice it, if you're not making equal distributions to your children, it can create a massive rod for your estates back, essentially. So we've acted in matters where father dies, has a daughter that he gets on very well with, and then two estranged sons. The two estranged sons were completely cut out of the will. Everything was going to the daughter. He hadn't seen them in about 30 years. Estranged son number one worked for the government, made fairly modest salary, owned a house, didn't really need any money. Second son didn't own anything, lived in a caravan park, had a drug habit, needed the money quite badly. Unsurprisingly, estate lawyers came in for both brothers and made an application to the court and said, you need to provide for these two other children. Now, the daughter we acted for, she was the one that was meant to get the entire estate. Because estate lawyers get paid out of the estate pool, everyone went to a mediation and we went, this is costing the estate more and more money. The longer that this goes on, if it goes to trial, it's going to cost more and more money, and that estate's just going to slowly shrink and shrink and shrink. So of the about $1 million estate, $100,000 went to the first son because he held out and he went, I'll eventually get them to pay me some money. They don't want this thing to go to court. The second son, who was the caravan park son, just went, I really just need some cash. I'm going to keep negotiating down with you, and settled for $10,000. And the residuary of the estate went to our client. Unfortunately for her, all of the legal fees comes out for the estate. So not only our fees, but also the other two sons' fees. So everything comes out of the estate first, and then the balance or the residuary goes to the beneficiary. So she walked away with a fraction of what she should have been getting in the first place. Now, unfortunately, the father didn't provide for why he didn't want his sons to get any interest from his estate. So when in doubt, the court, if you don't tell the executors and you don't tell the courts essentially why you don't want one child to get something, then the courts go, well, they're your children, they should each get a third each. It's got to be very clear, and it's called a statement of wishes that you can do, which provides for exactly how you want your estate to be administered. So the benefit of estate planning is there's a million ways you can do it, but if you don't have one, it creates a massive problem for you and creates a significant expense for your estate when they've already got to deal with the emotional trauma of losing a loved one.
I'm the firstborn and the favourite, so I'm going to tell my mum she's got to write down 87.5% from me. So, look, here's a real rough guide to what's in and out of the estate. So, anything that you own personally will be in the property, with the exception of things that are jointly owned. So, when you go and bought a house, you probably had, how do you want to hold the property? Do you want to hold it jointly or as tenants in common? Has everyone done that? Does everyone know if they hold jointly or as tenants in common? Who owns property jointly? And who owns as tenants in common? Well, who owns it on their own, I suppose? Yeah, okay. So the difference between joint tenancy and tenants in common is really just one basic difference. If you own property jointly and you die, it just goes to the other joint owner. If it's tenants in common, it'll fall into this part. It'll fall into your property as part of the estate. So that's that distinction, and hopefully your lawyer explained that to you when you were signing your contract for the property together. But so that will fall outside of your estate, and so will things like your family trust. So your family trust, there's basically, that is simply property that's held by the trustee, which you might be the trustee, but it'll be held for the benefit of all the beneficiaries. So that's not actually, even though you've put the stuff into the trust, that's not your property anymore, that's the trust's property. So it won't be administered as part of your estate, but you will need to deal with it. So if you are the trustee of the trust, you'll have to go through the wording of the trust, or you won't, hopefully your lawyer will, and work out how are we going to get control of this trust over to who I want to have control of it in the future. And then super really depends on what you've done in terms of binding nominations and things like that. So it will totally be dealt with in accordance with what you have and haven't done in terms of your estate planning.
It's a good segue into asset protection. All of you, I'm sure after yesterday's session on insurance and the risks of being sued and everything else, are very wary. It's been drummed into your entire careers of med neg and all the other issues that can potentially come at you. Estate planning is essentially asset protection. So as Craig said, if you have family trusts or testamentary trusts and the like, it provides that should you pass away, then that money and those assets automatically flow into the trust, and it's no longer your money and your assets. So if you're being sued by someone for a medical, or you're going to be sued by someone for a medical negligence claim, it can have the effect of protecting your family and your estate from that person. Obviously, corporations, you've got the corporate veil, but in a med-neg claim, you're almost likely to be sued as well. So there's not much protection that you guys can garner other than taking full advantage of trusts where possible, and having really good insurance. So look, asset protection and estate planning, you're almost always, there's probably at some stage in your career, someone's going to make a claim against you. It's just a fact of life, whether it's med-neg, an employee making a claim, another entity making a claim against you for some breach of contract or otherwise. The world's getting more litigious, unfortunately. So you're going to have to deal with these things at some stage potentially in your career. Additionally, if you're taking up a leased premises, most of you will be asked, particularly when you're starting up a practice in its infancy, to sign the lease as a guarantor, even if you are signing the lease as a trust or as a company. So essentially, if you're starting up a business taking a lease, the landlord wants to ensure that your new infant company can pay the bills. And if your new infant company has no trading history, the best way to secure your lease is to get director or guarantees from you personally to ensure that there's no issues for them in the future. So they can come after you even if your entity crumbles into a heap. So there's a lot of risk for you guys. So definitely taking the time to ensure that your estate planning is all in one nice piece and that your business structure and everything else is really well documented and protected to keep you and your assets safe. That's the best thing you guys can do in the long run.
Here's a bit of a horror story for you to let you know how it can shake out if you don't do all of this stuff. So we had it's not a medical matter. This guy was a FIFO worker in Queensland. He did a will many years ago, way before children, and he went down to the post office and he got the will kit and he saved himself, I don't know what the price of getting the lawyer to do it versus the will kit was, probably in the 80s maybe. But the public trustee was the executor under this will. So that means basically they make all the decisions about how the will's going to be administered. And they also charge a pretty penny to do so. So, if in my will, my wife's the executor, and in my wife's will, I'm the executor, so that's free administration. Public trustee, you're on the clock the whole time. And if they spend hours and hours and hours dealing with it, that all comes out of the money available for your family. Had plenty of money in the super fund, also had a substantial insurance policy in the super fund. No binding death benefit nominations. And so you put those two things together, you've got the public trustee, you've got no binding death benefit nomination. Very sudden death. And so what happened was that the public trustee and the super fund, in their infinite wisdom, decided, well, he's put this insurance in place, it's got to be all for the benefit of his kids, so it should just stay in trust till they're 18. Now, in the meantime, the wife's got no money, bills to pay, mortgage, all this stuff. She has a very immediate and very serious need for cash, and she's just lost her husband, she's taking care of the kids. It's a total disaster. So they basically had to run off to court to get those orders, which we successfully got for them, but took a year and it cost them tens of thousands of dollars to do so, because the court they're very busy, they're backed up, and unfortunately, even though she had this screamingly urgent need for money, she had to wait the full 12 months. Now, thankfully, because we could demonstrate that there was money coming and it was all going to be fine in the end, we were able to get her some bridging finance and things with some help of some other professionals, but it cost a whole heap of money, and all this stuff with the public trustee turning up to court and all that stuff all came off the bill as well, so it was a real disaster. So,
doesn't the public trustee have like protocols to follow if there's dependent children and things like that?
well, so it's
It's surprising that they just jumped to that.
well, so it's an interesting because with the super fund, it's the super fund's the one with the discretion about how the funds are going to be administered. So, if you don't have the binding death benefit nomination, they decide where to pay it, and that's just where they landed in this instance.
Unfortunately, the public trustee as well went, there's all this pool that's going into a trust for the children. Seemingly that trust, because it wasn't properly set out, was intended to be made available to them on the age of 18. And it hadn't expressly provided for fees to be paid out of the trust to cover living expenses and other expenses and schooling education expenses. So the public trustee does the best they can to administer the estate, and certainly has to follow their processes and procedures, but they usually are on the side of caution and keep the money available for the children when they're 18 rather than potentially giving it to the mum to administer and she's just going to burn it all up.
And look, super funds do operate on funds under management. The longer it stays in the super fund, the better it is for the super fund. So, yeah, it was very sad, but unfortunately, a bit of money was spent. But look, we got there in the end and it all worked out, but it was definitely a headache that could have been saved.
Yep. So look, in terms of a will, it's best if you can always take into consideration everyone in your family in terms of updating a will or having a will done. If you have children, you definitely need to have a will. But essentially update a will whenever there's a big life event. So if you haven't had children yet or you're not married yet, do a new will when you get married, do a new will when you have children. If you only provided for one child but you've got 3 children now, you need to review your will and ensure that it provides for all 3 of them. And then once you've gone through those big life events, potentially looking to review it at least every 5 to 10 years, just to make sure that what your current position is currently reflected in your estate plan. So definitely talk to your advisors and just make sure that it's all properly documented.
Okay, so I think we've spoken about these previously, and anyone that we spoke to last night, we will have talked about testamentary trusts quite a bit. It's basically just another form of discretionary trust that's created under a will. And again, it falls out of the estate, so it is something that will be quarantined potentially from any claims on the estate. But it doesn't give full protection. So, because what will happen is if everything's in a family trust and you've got this disappointed beneficiary, you know, you've got the son that you tried to write out of the will for whatever reason, what the court can do is they'll go, well, look, your daughter here is going to be taken care of because she's effectively going to get money through this trust and through these other things. So it's not completely foolproof because whatever is left in the estate, it can potentially change how that ends up getting dealt with. But look, it is a bit of a barrier. So, and then the other thing we've got is a super proceeds trust, and that is basically another type of trust that is created to accept some super funds into this trust. And basically, if you want to set up a super proceeds trust, which will probably be in consultation with your accountant, you have to take certain steps because basically only eligible death benefit nominees can be beneficiaries of that trust. And then what you'll have to do is basically direct some super by way of a binding death benefit nomination to your executor to establish that trust. So.